This conference will now be recorded.
Good afternoon, everyone, and welcome back to this episode of Digital Law News. So this is brought to you by Digital Law and produced by Anson Evaluate. So just for those who don't know, Digital Law is a small law firm based in Barnsley, UK, which specialises in anything to do with technology and digital matters, such as data protection and international data transfers. So I'm joined by my colleague Peter today, so I'll just pass you over to Peter just to introduce himself.
Thanks, Laura. I'm Peter, the Solicitor Managing Director at Digital Law, and yeah, we'll just be giving you a run through of interesting stories from the last 7 days with regards to law, technology, data, cyber, software, and technology as a whole.
Great. So our first story today is in relation to a data breach that was reported by Hackney Council. So they actually reported this, I think it was only yesterday or maybe the day before. And Hackney Council have actually reported a data breach that they have, and they've been hit by a serious cybersecurity attack, which has affected many of its services and IT systems, which they're still having problems with at the moment. And they have now said that the council are working with the NCSC and the Ministry of Housing in order to investigate. It's not clear yet what type of cyber attack they've suffered or to the extent of the data breach. However, a spokesperson from the ICO have said that they have confirmed that they have received a report of a data breach. So there's definitely a data breach has happened. They just don't know the extents to what's happened yet.
Thanks, Laura. Yeah, quite an interesting breach here insofar as it's a local authority, and it's interesting that the public sector still suffers massively when it comes to data protection breaches, both in terms of problems when related to things like malware and ransomware, as well as the sort of stray emails being sent by insiders. So famously, it's local authorities that up until massive fines for Facebook and TalkTalk, it was local authorities like NHS hospital trusts and councils that ended up picking up some of the highest record fines under the old Data Protection Act before GDPR and its large, big fines came along. And this is showing that it's still local authorities that very often are very vulnerable. This is because they very often got a lot of old legacy technology, lots of various different patches and updates on there. Sometimes these end up being missed out. Sometimes you've got old systems that are no longer being supported. That's how the NHS fell victim to WannaCry a few years ago. And it looks like it may have happened again here, though it'll be interesting to see the actual cause of the breach. Is it, for example, the incorrect information being sent out to someone? Or is it an email or series of emails being sent out to the wrong recipients? Or is it that sort of malware or ransomware breach? It will be interesting to see. The fact that they have also liaised with the National Cybersecurity Centre suggests that it is a large-scale breach as well.
Yeah, definitely. I think the fact that they've got in touch with NCSC already after only, 24 hours, shows that they think it's a bit more than just a simple like a phishing email or something. It's probably on the bigger side, the malware or the ransomware, like we've discussed in previous sessions.
Yes, yeah. I mean, I think this also, Laura, you and I have worked with some local authorities, and you tend to find there is regrettably a bit of a tick box approach to compliance when it comes to data protection and cyber security. And when you try and sort of raise these issues with them, they go, oh yes, we're following everything that we need to, and they've clearly had sort of tablets of stone handed down from, the IT team at the local authority, or if it's central government, they've had this passed down from Whitehall, this is what you need to do. And they think, well, this is what we're doing, therefore we are safe. And of course, you can't do that. Risk evolves over time. You can't just turn around and say, oh yes, we made ourselves secure last year, so I've got nothing to worry about. It doesn't work like that. And that there is sometimes even, I think, a reluctance to take responsibility for it in different teams and within the leadership, where it's very much felt that, oh, this is an IT thing, IT are on top of it, so we don't have to worry. And I think that's why, unfortunately, you still get these quite large-scale cyber attacks within for local authorities and the public sector as a whole.
Definitely. So I'm sure this will be one that we'll be coming back to with an update as to what caused the attack or anything from the ICO's investigation into it as well.
Exactly, and as they investigate, who knows if they'll end up finding if there has been any failing, and if you then get enforcement that follows on. But interesting that this has been publicised so quickly.
Definitely. So moving on to our next story, this is one staying with the ICO as well. So the privacy watchdog is probing into Klarna after email backlash. So the ICO are making inquiries into Klarna after scores of angry people are being questioned why it had their details despite never doing business with the payments firm. So some of you may know that Klarna is kind of a payments firm where they offer an option on many large websites to have a pay later option. So instead of paying up front, you might pay later, which comes with some other problems, but let's not talk about that. So, but yeah, a lot of people received a marketing email from Klarna, even though they've never had communications with them or used their services. And this marketing email was then followed by a small message just saying, don't worry, this was an error. You've not been added to our marketing server. So people are now questioning where they got this information from, where they got people's emails from in the first place, and maybe whether someone has sold them their data.
Exactly, and in the circumstances, it looks like that's probably quite likely. I think this highlights the difficulties of continuing with what the marketing approaches that some organisations may have taken over the years to sort of build up their client bases. In the past, people have just ended up buying email addresses. Right, I've brought 10,000 email addresses, now I can send out marketing emails. And even if you only get click-throughs from a few percent of those and only 1% end up buying something, it's very often been a worthwhile exercise for them. But of course, now, if you do that on a large scale, and it only takes then a few percent of the recipients to then complain about that and complain to the ICO, as happened here, and then you can trigger the ICO taking a look, investigating, and potentially carrying out enforcement. And I think this highlights really the difficulty of continuing with that sort of old way of marketing of, yes, let's go and buy a load of contact. And we are looking here not just at data protection, it's also e-privacy when it comes to sending these marketing emails out. So ordinarily, you'd have to make sure that there's, like, for example, a one-click way that the recipient can cancel receiving any more emails without having to sort of go through and register loads of information to stop receiving it. They should just be able to say, stop contacting me. But the other thing is that it's very difficult. In this instance, Klarna will be approached by the ICO, who will say, what's the basis upon which you've been processing these individuals, these recipients' email addresses? Then this is, of course, that basic principle under Article 6. What's the basis for processing? So can you argue somehow that it's legitimate business? Well, given that they weren't previous customers of Klarna, you can't argue it's a legitimate business interest to be then sending out marketing information. So really, it's then going to be, well, have you got consent from these users? Wherever you got the information from, did the users previously give their consent knowingly that they were then going to be contacted for sales and marketing purposes? And unless you can demonstrate that, you're in difficulties. So yeah, this is a really risky one here for Klarna. How do you account for the basis upon which you've been processing all these email addresses? And if they can't account for that, then we'll be looking at enforcement from the ICO. And I think they'll make a bit of an example of Klarna for this, because Laura, you and I have both had clients that come to us saying, oh yes, we want to go ahead and buy a load of personal data so we can use it for marketing purposes. What do we need to do in order to comply with GDPR? And we always say, well, it's very difficult. You need to have the evidence so that if you do get the ICO coming calling, you can explain why you're processing this information. So it's not an easy, just ask this question, ask that question, and then you can say, yes, we're fairly processing this stuff. You have to have the evidence. And if that isn't provided to you by the vendor that's given you the information in the first place, you're going to have a problem.
Yeah, definitely. Yeah, that's one biggest thing that we tell our clients. It's no good just doing everything that you need to do in terms of GDPR compliance. You need to actually evidence it as well, because that's what the ICO are going to be looking for if something does go wrong, or if you do get into trouble, like sending emails to the wrong people. As long as you've got it evidenced, you're kind of covered. But if you haven't,
Exactly.
then you're not.
It's our two favourite words, isn't it, Laura? What are they?
I'm not sure.
Yeah. So it's that one. It's always demonstrate compliance, isn't it? It's just
Yeah.
how do you demonstrate? It's all very well saying yes, we're compliant. How do you demonstrate that either to the regulator or to a third party or to a supplier or a customer? How do you say yes, we're compliant? And that's where you demonstrate it. So you're quite right. It's just having that evidence. How do you demonstrate that compliance?
Yeah. And like I said before with the previous story, this will probably one we'll be looking at again, whether the ICO actually do end up investigating this and then do a report on it. Probably come back to it in the future.
I suspect so.
So moving on to the next one, ICO related again. So this is ICO have already taken action against a company. So the company is Studios MG Limited, which is a London-based software consultancy. And they actually tried to exploit the public health emergency back in April this year by sending up to 9,000 unlawful marketing emails to people without their permission. So these emails were in relation to buying a face mask off them. And since the ICO have launched their investigation, they found that the company was not involved in the business of supplying PPE, but rather the director had decided to buy face masks and sell them off on a profit, probably as a way to make a little bit of money while they weren't making much in the midst of the pandemic. So the ICO have also found that Studios MG deleted a lot of the evidence which showed the full extent of the volume of emails they'd sent. So now they've been issued with a fine of £40,000 by the ICO and have been issued with an enforcement notice. So they've now got 30 days to make sure they're basically stop sending these emails if they are continuing to do so.
Thanks, Laura. I think this is a fascinating piece of enforcement from the ICO here. So unlike the last story, this isn't a matter of, oh, they're investigating. They have investigated and they are issuing a fine and they are wanting them to stop. And I mean, this is very speedy, comparatively speedy action from the ICO. Incident in April, which will have had to be reported, they'll have had to investigate. And despite the difficulties of the lockdown and the volume of work they're having to do about it, they have fast-tracked this and they've announced the enforcement. I think the key takeaways from it are that we know there are a lot of different apps that ended up, a lot of organizations trying to make hay out of the pandemic earlier this year, selling everything from PPE to coronavirus, private coronavirus tests for those who wanted to pay for a test to be administered. And a lot of people made a quick buck very quickly, profiting out of others' misfortune and fear, to put it bluntly. So I think it's quite, even though here they're obviously the ICO is coming down on this from a data protection perspective, it's arguably there's an ethical reason, I think, to clamp down on those who've sought here to make a quick buck from getting into the PPE market very, very suddenly, and perhaps, you know, not necessarily sourcing their equipment from reliable sources and just wanting to carpet bomb people with marketing emails, panic them into buying a load of masks, not necessarily good quality equipment and not necessarily at a good market rate. So it's good that the ICO has said, you know what, we're actually going to come down hard on this, and they have done, and I hope they continue to with this pattern of enforcement as well, because I think there's been a lot of unscrupulous actors out there during the lockdown trying to sort of sell PPE, sell other pandemic-related equipment, and I think it is a positive as a result that the ICO is being proactive and taking this enforcement.
Yeah, definitely. I think, like you said, there's been a lot of people, like bad actors, as they say, taking advantage of the pandemic, and this just proves that you can't get away with it in terms of data protection and so forth.
Exactly.
Yeah. So moving on to the next story then. So this is regarding cybersecurity guidance published by the NCSC. So I think this guidance was already out there. However, the NCSC have revamped their cyber guide for small businesses, because they've realised that a lot of small businesses now are working online and operating online, whether they did before or whether they kind of just a shop, corner local shop before, or just small business. They didn't have any online presence, but have now had to move online due to everything that's gone on this year. So the NCSC have revamped this guidance, and it sets out some key areas for business cybersecurity. So the latest raft of measures focus on 5 key points for businesses. So the first one is backing up your data. Secondly, protecting your organisation from malware. Thirdly, keeping your smartphones and tablets safe. Number 4 is using passwords to protect your data, and number 5 is avoiding phishing attacks. So this is just basically a small piece of guidance that a lot of firms will probably find helpful. It's kind of like the basics things that you need to be doing to help your business really, just keep it safe from cyber attacks.
Exactly, and I think this is really, I think while these are fairly straightforward, easy bits of guidance and measures that organisations can take, the fact it's the National Cyber Security Centre saying this hopefully gives it more weight. Laura, you'll know that we end up making all 5 of those points and many others to our clients, and sometimes they can say, yes, we're already doing that, but sometimes you get pushback. Just this week, we've spoken to clients about backing up data, particularly on the back of the story in last week's discussion where we talked about the Microsoft cloud having gone down. So we've been saying to clients, make sure you are not reliant on one provider. Just because you're using a large provider like Microsoft or Amazon, do not presume that their service will be available 24 hours a day, 7 days a week. If that service goes down, what are you going to do then? And yet, I think sometimes there's a reluctance by developers when they're developing systems, when they're developing apps, when they're doing new websites to think, yeah, we have a separate independent backup on a separate system that we can fall back on if the worst should happen. As always, hope for the worst, plan for the best. Sorry, the other way around. Hope for the best, plan for the worst. But the key thing there is just make sure that you've got a mechanism in place. And that's the number one thing here that the National Cyber Security Centre have said. So I think we'll be probably doing a piece on our website on this in the course of the coming weeks. So if you're hearing this after we've recorded it, then feel free to take a look at our site where we'll be setting out these 5 steps that businesses should be taking, SMEs, and hopefully it helps, because I think sometimes for a lot of businesses out there, particularly if you're on the back foot this year after the pandemic and trying to pay your staff and having to spend money on changing the nature of your business so you can continue trading during these difficult conditions, being secure online may not be a priority. But if that is the case, and when trying to be secure becomes a bit overwhelming, if you do these 5 measures and nothing else, at least it's a start.
Yeah, definitely. I think a lot of companies and a lot of small businesses are kind of scared of the whole cybersecurity and data protection, because they think it's just very overwhelming, like you said, and just doing a few basic things can actually protect your business pretty well.
Exactly. It doesn't have to be difficult. It doesn't have to be complex. It doesn't have to be expensive. All 5 of these things do not have to. It's not a matter of reinventing the wheel or spending thousands of pounds to do it. A lot of it, some people might say, well, that's common sense. Well, yes, it may be.
Yeah.
But just because it's common sense doesn't mean that it's straightforward or easy, particularly when I appreciate that for a lot of the entrepreneurs running small businesses in this year have been under a huge amount of pressure. So I think now is a good time, if you can, just to take a little bit of time just to think, are we taking these 5 straightforward steps just to make sure that we are protecting our business as much as possible? Because regrettably, there are unscrupulous people out there. There are bad actors who are looking to compromise businesses and steal their data and hack into their finances. So the more difficult you can make it for them by following these 5 steps, the better.
Great. So yeah, moving on to the next story then. So this is one that I thought I'd just add in today. Probably not talk much about it, just quickly glance over it. But we have spoke about Huawei over the past couple of months quite a lot. So I thought it would be a bit strange for us not to mention this. So the Cabinet Office have actually published a report into Huawei's presence in the UK, covering the period of January 2019 to December 2019. So the report actually provides details analysis of the company's software, engineering and cyber security processes, and details the actions required of the company as a result. So I've just provided a link there on the presentation for the report as well. It is quite a lengthy document. I think it's about 45 pages. So it is quite a lengthy one to read through, but some people might find it interesting.
Thanks. So I think this is a good story to cover because it ties in with a lot of the discussions we were having a few months ago around Huawei and the fact that the UK government is now taking actions to strip Huawei out of the 5G and 4G network over the next 5 years. And this is the evidence here saying this is what we have seen from their activity between January 19 and December 19. And I think there'll be, you know, there is the evidence in here to suggest why the government has been concerned and why they've ended up taking the action that they have. Interestingly, in the meantime, I don't know if the eyes and ears are out there are watching and listening, but it was a slightly scary moment when I was checking back through our Twitter account the other day, and I found that digital law is being followed on Twitter by Huawei. So I suspect it was something we said. But if you are listening, people from Huawei UK or even in Beijing, hello, and you know, what we are doing is reporting to our users and our clients on the reasons why Huawei is being stripped out of the network. So, and here, as I say, is the evidence from the National Cybersecurity Centre on why. But it is a long-term project now while Huawei is removed from the network, and there are obviously similar actions are being undertaken in the United States and across the Five Eyes countries as well. So Australia, Canada, New Zealand as well, to make sure there is not a risk to critical national infrastructure from the use of Huawei 5G and 4G equipment in those systems.
Great. Yeah, that's just a little brief overview of that. But yeah, so we'll just move on to the next one. So the next one is coming back to the ICO once again. But this is in regards to an investigation they're carrying out. So the ICO have actually confirmed that it is written to 15 companies, all of whom provide contact tracing services to the hospitality sector in order to assess their data protection practices, including the way that they are carrying out direct marketing. So it's come after reports that companies are potentially selling consumer data. So this is something we've spoke about quite a few times since the whole since pubs reopened and restaurants reopened, and a lot of companies were starting to produce apps to help the hospitality sector to be able to track and trace, basically. So a spokesperson from the ICO have said that the rules are clear. Collecting personal data for consumer logs must be not to develop the vast marketing databases by the back door. And it's also, according to the Times as well, a lot of companies are thought to have been taking advantage and exploiting the QR barcodes to harvest more confidential data than is actually needed.
Indeed. Thanks, Laura. I mean, we actually did quite a detailed webinar on the standards that hospitality has to follow when it comes to the collection of data for test and trace back in June, when the hospitality sector was getting ready to reopen on the 4th of July. And it was clear then that there were a lot of apps and systems out there saying, yes, we can help hospitality by helping you to keep a log of people making reservations online for your tables and making reservations for food or drinks, and helping people to make those reservations or indeed carry out their orders online. And Clearly, a lot of those apps were set up very, very quickly to provide a support and a service to the market. And I think, unfortunately, data protection was not particularly top of mind for many of those providers. So it is very much a case of actually taking a look and thinking, actually, what system have we been using? Is it potentially one of these 15 companies that is being used? I mean, this is actually, I think, a major incentive to anyone out there who's looking at this and thinking, whoa, well, I think that's happened to me because I've started receiving spam from different bars and restaurants and organizations that I never went anywhere near. But I've seen an increase in spam and unsolicited marketing emails, since the summer. You might think, well, yeah, perhaps I shouldn't have, perhaps that's from me having registered and left an email address somewhere. I think it's actually a good reason to actually download and use the official NHS app, because of course you can scan that via the barcode, the QR code, when you go into any bar or restaurant, and anyone who's downloaded the NHS app knows that of course you haven't had to enter personal detail into that app in order to do so. So it's merely logging the fact that you're going in there, and then that's only kept to match up with that place, so that if you find out if someone who was in that hospitality area when you were there ends up testing positive, then the test and trace system can do its stuff. But at least it means you aren't having to leave, writing down your email address or entering it on a dodgy app or something, because we know that this has been quite widespread. We've had stories of people receiving spam emails. We've even had stories of staff in the hospitality sector using the personal data that customers have left behind to then get in touch with those customers afterwards, just to say, hello there, you're at the bar, can I have your phone number? Which is creepy, to say the least. And I think this is, the ICO has to act on this. They have to show that that sort of behaviour is simply unacceptable and illegal.
Yeah, definitely. Yeah, I think these issues may come to a slow decline now, as like you said, the NHS app has been introduced, and a lot of people are just either using it off their own back, or restaurants are actually telling you to use it. So yeah, this should decline, and hopefully people stop using the data for the wrong purposes.
Yeah, but I can see, they're contacting these 15 tracing companies. It wouldn't surprise me if one or two of those companies end up being nailed to the wall with a few fines as an example to the rest, to say, don't think you're going to get away doing that again. And let's not forget that we are potentially still in the early stages of this global pandemic. There are going to be various different restrictions for a period of years until everyone gets some form of effective vaccine, if that ever happens. In the meantime, different technical solutions will keep on being created by the unscrupulous people out there to just bodge something together and try and comply with a restriction as it's been imposed. So I think it's just a word to the wise to say, look, be careful of the systems that you might invest in to help your organisation comply with the restrictions in your sector.
Yeah, definitely. So moving on to our last story. So this is in regards to a data breach incident that took place in March of 2020. So it was thought that Virgin Media actually had a data breach in March this year, after basically a database could be found online. It was unprotected, and you could just basically search for it online and find a database of its customers' data. So a consumer action law firm, Your Lawyers, has now launched a class action suit against it. So they have announced a group action claim against the broadband internet service provider Virgin Media. However, they are waiting and giving Virgin Media the option of admitting liability. And if they do not admit liability within around a month, I think it is, then they're going to file an application for the group litigation order in order to formalise the action and seek justice for those affected. So far they've got around 2,000 claimants that they're going to be representing in this case, and they have said that obviously they could be eligible up to £5,000 of compensation. So I think that came to in total about £4.5 million that Virgin Media would be paying out as a result of this.
Indeed, the biggest single liability that Virgin Media might face as a result of this breach could be that liability to the individual data subjects. I mean, it's interesting that we've got a large potential cohort there, almost 900,000 customers, and it is now easier to be able to put together a potential action like this than it was before GDPR came in and before the Google case a few years ago that led to sort of flat rates being introduced in terms of the amount that people had could be compensated if they were victims of a data protection breach. So before the Google case, it was always down to the data subject to actually prove that there had been a loss. You had to turn around and say, well, you know, my information has been breached, and as a result, you know, so for example, someone opened a credit card in my name, they ran up £10,000 worth of debt, and now I'm stuck with that, so I'm claiming £10,000. You had to have a clear evidential chain to say, this is the loss I have sustained because of that breach. But since then, it's now the case that the courts are turning around and saying, well, if you've been the victim of a data protection breach, we'll look at the nature of the data and then just make a flat award in that respect. So you could be looking at, in this instance, something like £4,000 or £5,000 per individual. Highest awards made, I've heard so far, are about between £15,000 and £20,000, where things like people's criminal records ended up being breached online. So you can imagine if it's, say, if it was like really sensitive data like criminal records, medical records, more would be awarded by the court. In fact, we're looking at about £5,000. Suggests it's the usual sort of name, email address, perhaps billing information as well, that's led to that's been leaked online, hence the nature of the award. But I think we are now in a world where we'll be seeing more of these sorts of class actions. Probably the leading class action of this type so far was the Morrison's data protection breach after the Morrison's payroll was breached back in 2014, and it took the best part of 5 years for that one to finally make its way through the courts. So it'll be interesting to see what happens with this one.
Yeah, and I think we was discussing this earlier, whether if the ICO actually brought action against them and fined them for this, or another data regulator did, whether that would have an effect on the class action suit as well.
It may well do, and I mean, in this instance, we seem to be comparatively early on in this with regards to the fact that the consumer law firm is saying that Virgin Media has 4 weeks to admit liability. Well, whether it takes them 4 weeks or not remains to be seen. But of course, if Virgin Media ended up being fined, you know, if they faced an enforcement action and an investigation enforcement and were fined by the ICO, well, that would then mean you couldn't turn around and then say, oh, you know, we aren't going to admit liability for this. So it's actually similar to in, for example, some criminal and civil matters. Say if you had a road accident and someone ended up being seriously injured as a result, very often an injury claim follows a successful criminal conviction for someone for example, dangerous driving, because then on the back of the criminal investigation, you've got the police accident report book, you've got a conviction that is beyond reasonable doubt. So then balance the probabilities in the civil courts, you can potentially make your claim for say personal injury, loss of income, loss of earnings, as well as personal injuries against then that individual, or more often than not their insurer. In this instance, of course, if you therefore got a regulatory notice to say clearly you now can't possibly defend this, that's going to make it even more straightforward to get your cohort together and make a claim. If anything, the regulator would act significantly more quickly on this compared to an action in the civil courts, because when you've got such a large number of potential claimants, and we've got potentially hundreds of thousands here, then the court, if there's no admission of liability, the court will get involved. The court will then say, well, we'll open the group register, and that has to open up, and then the solicitors have to register all of the clients they've got on there, and it's quite an administrative nightmare for the court to deal with the litigation and granting group litigation orders where you've got these huge numbers of claimants. And indeed, they tend to roll on for a very long period of time if it ends up being litigated. So sadly, any of those customers could be looking at 4 or 5 years until they actually get a settlement if it goes to court. Indeed, your lawyers this consumer action firm will be hoping that Virgin Media simply folds and wants to just send out a load of checks for £5,000 to each of their clients. Because of course that would be an awful lot quicker for all involved, and then of course Virgin Media would also have to pay the costs for the consumer action firm as well, which would probably be just as much as the awards that are being paid to the individual clients. So there is certainly something in it for them as well, but they'll be hoping, yes, that Virgin Media folds rather than pushing it all the way to a hearing. Otherwise this would roll on and on and on into the middle of this decade.
Yeah, definitely. Like we keep saying, this is probably not one we'll come back to in a couple of weeks.
Coming weeks and potentially coming years, who knows?
Yeah, definitely. Yeah, so that was our last story for today. So just want to remind everyone again about the special offer we have on for our listeners. So we have the GDPR compliance manual for legal practices, which came on sale in 2018 when GDPR came into force. So this was originally sold for £195. However, it's got around a 50% discount on at the moment, and we are now selling it for £99. So it's available in hard copy for an additional £5 for postal packaging, and in digital copy as well. So do you want to just say something about it, Peter?
Yes, so this is our GDPR compliance manual that contains things like forms and templates and checklists, practical, helpful tools to help you get a handle on your GDPR compliance, which we know can sometimes be very overwhelming to organisations that are trying to get a handle on it. So this contains the tools. It's written in clear, plain English, and tries to help you get your organisation to a point where you can actively demonstrate compliance to the regulators, and in this instance it's for law firms, so both the ICO and the SRA, the Solicitors Regulatory Authority.
Great. So that's everything for today. Please do look out for our blog post that we'll be posting within the next couple of days or weeks regarding the NCSC's guidance as well. So we're probably just going into a little bit more detail on that as well. Just to remind everyone, this is available on demand through our website, our YouTube channel, and our podcast channels as well. So on Spotify and the Apple Store or any other platform you want to listen to us on. Sorry, I can't speak. So thank you for listening again, and we will see you next week.